Hello, 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 and welcome everybody. All right. Hello, Carol. Hello and welcome. K-Mitch, I see your hello on the other screen on my studio, but it's not up on my restream. So I don't know why, but it isn't. Let me just do this, put it back. It's weird. But I see you there, Carol. I see you, K-Mitch. Okay, so the judge has entered his orders regarding the motion to continue and regarding the defense's motions to offer proof of alternate perpetrators. So he's got an order on both. We're going to go over those. I'm glad you got the notification too, Jean. And hello. There's Tammy. Hello. Welcome, everybody. Okay, so let me get this up for you guys. Okay, so here it is. I've blown it up as much as I can. I'm doing good, Jean. How are you? I hope you're doing well too. Yeah, I can see you now, K-Mitch, but it's because the stream hadn't started yet when you put that in, so it doesn't come up on my restream. It comes up in my YouTube studio, but it doesn't come up on my YouTube my restream chat box. There's Nana. Hello, Nana. Yes, we are doing the Kohberger case. Okay, so here it is, you guys, and we're going to go over it. There's a lot of things in here where the judge takes some good digs at the defense, right? Now, if you guys remember correctly, a while back, we did cover some of the court hearings, the motions that the defense had filed. We were able to stream them. And Anne was complaining a lot. And there's Rose. So good to see you, Rose. Yeah, it's showing as K-Mitch. But it's good to see Rose. Haven't seen Rose in a while, so it's good to always see you. Yes, thank you. Thank you for hitting that thumbs up. It gets it out there. There's nothing more that irritates me more than having to stop and answer questions from stuff we covered like half an hour ago, right? But we're just starting, so yes, thank you for hitting that thumbs up and getting it out there in the algorithm so we can get going on this. Let me see if I can't get a better... hang on a sec, you guys. See if I can't get this bigger. No. Well, I guess it does go a little bit bigger. So let's do this. All right, that's a little bit bigger. It cuts out everything else. Thank you so much, Rose. You are awesome. Rose has started the super chat super sticker train. She is the conductor. So jump on aboard, you guys. I appreciate all the support. It helps me to continue bringing these cases to you and the information. I told you guys that I would be watching these cases. I'm still watching the Morphew one too, the Barry Morphew, waiting to see when he is brought back, and hopefully that is going to be very soon that he's brought back, extradited to Colorado. Once he is, you guys know I'm going to bring that to you too. Fan character bouncing their heart-shaped ponytail with stars in their eye. You're adorable. You are adorable. Courtney, good morning. Just giving you some love. Thank you so much, Rose. Rose is just giving you some love. Good morning, Courtney. Yes, thank you so much. Rose is just awesome. There's Lori. Okay, so let's oh, thank you, Rose. I appreciate you so much. So much. Okay, so let's jump into this. So this is redacted. Some of it is redacted. Whoops, this isn't the one that I wanted to show you. It was this one. Hang on. We're going to get to this one, you guys, the alternate perps. But I want to go over the... Which one is this? I want to go over this one. Here it is. This is for the motion to continue. Yes, it is. They're both crazy. Thought you were talking about Barry. Nope, there's nothing new in his case. I've already gone over the documents that had come out already with the two lawyers, one of which, Jean, represented him also in the first trial. She was kind of like in the background, and she represented him in the civil trial that was dismissed. So she is, but it's for a limited purpose for first appearance only for both attorneys in the Barry Morphew case. So neither one of them have been retained. So it's going to be interesting to see what happens there. Jean requested that all the documents be sent to Barry, and the other lawyer, what is his name? I got so many names in my head right now. I have them written down somewhere here. I don't have my glasses on. Hang on a sec, you guys. David Beller is the other one. He is also only for limited purpose for first appearance. So does he end up retaining one of these two? I don't know. But right now they are for limited purpose for first appearance only. And they both put that in. Go see my video that I did yesterday or the day before. I don't remember. You guys know my memory. I went through those. But right today we are on the Bryan Kohberger, and these are the new documents. We were really concerned about them getting a continuance, but let's see what the judge says. The judge also goes after the defense too, because they tried this a couple months ago, and the judge says, well, I'm going to put in a word that you need extra help and that you should be able to get extra help, and all she's going to have to do is file the paperwork, and let's see if she did that. She keeps continuing saying that she, can't get through all this stuff and whatnot, and all these requests for discovery. The judge calls her out. So let's see what the judge has to say. I think he is on to her that she is just trying to continue this forever. So introduction, let's get through this. If I don't see you, it's because I'm paying attention on my other screen to the document. So hello, Susan. I'm not ignoring you guys. I'm just focused on the document. So I will glance over a little bit to see if you guys got questions or whatever, but I am going to focus on this document. It is 20 pages, as you can see up top here. Okay, so can you guys see? Yes, I can highlight. Great. Okay. So before the court is defendant's motion to continue the trial in this matter. The basis for the motion is threefold. First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review it all. Second, he asserts that there is a penalty phase investigation and preparation that still needs to be done. Third, he asserts that recent and forthcoming publicity on the case is highly prejudicial. Maintaining the current trial settings under these circumstances, he argues, will render any conviction and sentence unconstitutional. Well, I wonder if they would be saying that if he was found not guilty, right? The state responds that the defendant's motion is untimely and he has failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. Yes, he is a no-nonsense judge for sure, Gene. Oral argument on the motion was held on June 18th. We covered that, after which the court took the matter under advisement. The court finds a continuance is not warranted as the defendant has not made a showing that there is good cause to continue the trial or that substantial rights will be prejudiced by proceeding to trial as scheduled. And there's a little one here. We will look at that as we get down to the, well, let's go to the bottom of the page. So here it is here. Defendant filed some of his supporting materials ex parte. While the court is not convinced that much of his filing is necessary or appropriate to be treated as ex parte, the court will nevertheless, in abundance of caution, issue a redacted and unredacted version of this order, with the state only receiving the redacted version, given that the court is denying the defendant's motion. So that's what this little one was for right here. Standard. A motion to continuance of trial is addressed to the sound discretion of the trial court. And they cite a case here. On discretionary matters, the trial court must correctly perceive the issues as one of discretion, act within the outer boundaries of its discretion, and act consistently with the legal standards applicable to the specific choice available to it, and 4, reach its decision by the exercise of reason. Okay, and they do cite another case. Analysts. Under Idaho law, a criminal defendant seeking a continuance of trial must demonstrate that his or her substantial rights, and he quotes, substantial rights, will be prejudiced absent a continuance. They do cite another case here. Trial judges necessarily require a great deal of latitude in scheduling trials. The burden of assembling the witnesses, lawyers, and jurors at the place and time for trial counsels against continuances except for compelling reasons. There are no mechanical tests for deciding when a denial of continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time the request is denied. They also cite another case where a continuance is sought based on the late discovery or disclosure or discovery of evidence. The alleged tardiness of the discovery must be shown to so prejudice the defendant's case preparation that a fair trial would be denied. They state another case. The bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion for a continuance. Additionally, where a continuance is sought for the potential receipt of evidence from further investigation, the motion is properly denied if based on speculation. So he is saying a lot there. In other words, he is saying everything that you have said is just speculation. You have nothing to back it up. Defendant argues a continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigation evidence, particularly claimed newly revealed evidence that allegedly raises red flags. Well, red flags, is speculation. It's like, ooh, you better watch out for this. You better check into it. It's speculation. And remedy the prejudice caused by the recent and upcoming inflammatory publicity and the alleged leak of information to the media. Moving forward with trial, he warns, will violate his rights under the United States and Idaho's constitutions. We got a number 2 here. So let's go see what that is. Defendant specifically cites to the 5th, 6th, 8th, 14th Amendments to the U.S. Constitution and Article 6, 7, 8, and 13 of the Idaho Constitution. Notably, defendant does not argue that the Idaho Constitution provides any heightened protection than the U.S. Constitution with regard to the rights cited. Thus, the court will not engage in separate analysis under the Idaho Constitution. Okay? So that's what this number 2 right here means. Idaho's constitutions to due process, to be free from cruel and unusual punishment, to a fair trial, to effective assistance of counsel, to present a defense and confront witnesses, and to a fair and reliable sentencing determination. Absent from the defendant's materials, however, is any good cause for the continuance or legitimate showing of prejudice should the trial proceed as scheduled. So he is saying, you know what? You haven't shown me any material that shows good cause to back up this motion for a continuance or any legitimate showing of prejudice if the trial proceeds as it's stated, right? A, defendant has not demonstrated a continuance is warranted to review discovery. This gets interesting. This is 20 pages. We're on page 3. Defendant first contends that the vast amount of discovery in this case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to be comprehensively integrated into the defense. He further argues without any support or explanation. So he's saying he's making all, and when he says he's talking about Bryan Kohberger, right? He further argues without any support or explanation. So he's arguing these points, but he's not giving any support or explanation for what he's saying. He's just blatantly saying it. It's like, just throwing something out there to the wind to see if it's going to stick without giving any evidence or explanation or support for it. Okay, that there are a myriad of issues that continue to arise from the state failing to comply with discovery. Look at this. That continue to arise from the state failing to comply with discovery and expert disclosure deadlines. There is a number 3 here. Let's go see what that is. Because I think they're on the 24th motion for discovery, to force discovery, right? So let's go see what this number 3 here is saying. 3, defendant continues to complain, right here, number 3, whoops, not up there, right here, defendant continues to complain the state's discovery violations, but to be clear, this court has found no such violations by the state. So even though they continuously complain that they haven't got this discovery, the court has found no such violations by the state. Okay? Where are we? Here we go, right here. This is where we were at that number 3. A continuance, he argues, is necessary for counsel to mount an effective defense. The court, however, rejected this same argument 2 months ago when the defendant sought to strike the death penalty and impose discovery obligations upon the state. Okay? See the order on the defendant's motion to strike the death penalty and adopt other necessary procedures. We covered that, so you can go back and you can check that video that we did on April 29th. In its order, the court observed the utter lack of any proof. This is important, you guys. In its order, the court observed the utter lack of any proof supporting the defendant's accusations of discovery violations by the state. More importantly, the court found defendants' complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel had been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. Now, if you remember 2 months ago, he said you can go to the resource judge and ask for more help. Number 5, the defendants, right here, number 5, the defendant's continued reference to the number of terabytes of discovery produced in this case is not helpful. Without providing a meaningful explanation of what that data primarily consists of, is its particular relevance and importance. Indeed, as was discussed at the April 29, 2025 hearing, in this case, it appears that most of those terabytes consist of excessive video surveillance from local businesses and residents that show nothing of significance. In fact, the state indicated at that hearing that much of the discovery is completely irrelevant and stipulated that it is unaware of any Brady material in the video surveillance footage other than that specifically identified in motion practice. Given that the state has identified all its trial exhibits, the defense cannot be unaware, it continues down here, of all the incriminating evidence in the discovery. Finally, it should be noted that it was the defendant who early on demanded that the state provide all investigative materials, no matter how relevant or unhelpful. So you can't ask for all of this, whether it's relevant or not. You can't ask for it all and then complain because you were given so much information that you can't possibly go through it all. The prosecution has to turn over any inculpatory or exculpatory evidence they find, whether it's good for the defense or it's good for the prosecution. If there's a bunch of things that they have in there, like say 24 hours of video surveillance that doesn't even show any vehicle or anything passing by it, that's not considered discoverable, okay? Because there's nothing being shown. They're not going to be using it in court. There's nothing there that the defense could say, aha, see, look it. This shows a woman driver in a white car similar to Bryan Kohbergers. You know what I mean? So if there's nothing there, there's nothing there of evidentiary value. But the defense turned around and said, we don't care. We want it all anyway. So that's what they got. And now they're complaining that the prosecution gave them all these terabytes of stuff and they have to go through it. And most of it is garbage. You know what I mean? You can't ask for it and then use that as an argument. Okay? Defendant's second round of this argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He also, and there's a number 6 here. Let's go see what this number 6 is. I like to do that so we stay like flowing. So let's go see what number 6 is. The only discovery counsel claims that have not been fully reviewed are all the thousands of tips provided to law enforcement. She argues these tips may lead to the discovery of evidence of an alternate perpetrator. The deadline for presenting alternate perpetrator evidence has come and gone, with no motion by the defense to extend it. Further, to offer alternate perpetrator evidence, the defendant needs far more than unsubstantiated hearsay tip that another person could have committed the crime. So what they're saying is there was some tip that was called in that said, oh, so-and-so could have done it, with no evidence or anything to back that claim up. Isn't this what happened in Lori Daybell's? Isn't this what happened, including missing the deadline to turn it into the defense? No. This is totally different than the Lori Vallow trial. The Lori Vallow trial, I don't even want to get into it right now because we're on the Bryan Kohberger thing, but the prosecution took away her rights to a speedy trial, and they also withheld disclosure for long periods of time where she feels she should have had it, etc. And the judge found that that was to be true, even though that she was in a mental hospital. It should have still been turned over, even though the case had been stayed. That doesn't stop the prosecution from turning that over to her defense attorneys, even though nothing could be done about it at the time because the case was stayed. There was a lot of things that happened like that. That's not so in this case. Okay. He also fails to identify any steps his counsel has taken, particularly since the court's prior order to aid processing the yet unreviewed discovery. Okay, let's go to number 7. At the hearing on the defendant's motion to strike the death penalty based on his counsel's alleged inability to process discovery, we're right here, you guys. The court suggested several options counsel had to obtain assistance in discovery review. There is no evidence that the defense counsel has exercised any of those options, nor has there been any good explanation of why counsel has not sought additional resources to process and review discovery, such as the tips and security videos. The failure to do so suggests a recognition that this discovery was extremely unlikely to bear fruit. Okay? So they're just trying to throw everything in here, hoping maybe that the judge isn't going to fact check it. Moreover, he does not explain why he waited to seek a continuance until after discovery closed. Expert disclosure deadlines passed and the pretrial conference occurred. If defense counsel was truly struggling with discovery review, this motion should have been made when the claimed problem became apparent, and certainly should have been brought prior to the expiration of all discovery, all expert deadlines, and the final pretrial conference. Instead, defense counsel has robustly litigated this case, retaining approximately 24 experts and a full mitigation team, engaging in extensive motion practice and disclosing witnesses and exhibit lists with a nary a whisper that a continuance would be sought. These actions belie his counsel's ongoing and ultimately empty discovery complaints. Hello, Regina. And there is an 8 here. Let's go see what the 8 is. Relevant here, we're down here. Relevant here, too, is the fact that defense counsel did not argue for a continuance as an alternate remedy to the defendant's attempt to strike the death penalty because of counsel's alleged inability to get through the discovery. This highlights that his claims regarding the volume of discovery were used as a tactical sword untethered to a seriously legitimate concern about the ability to be prepared. Because she said, if you don't allow this, this is going to be ineffective of counsel. Like, he's calling her out. Like, you're using it as a tactical sword, untethered to a seriously legitimate concern about the ability to be prepared. Okay? Without more, the court can only conclude that the defense counsel, we're up here, just so you guys know where we are. Without more, the court can only conclude that the defense counsel is using the volume of discovery measured in terabytes as a tactic to delay the proceeding at the 11th hour simply for the sake of a delay, rather than a legitimate threat of prejudice to the defendant's substantial rights. Perhaps even more problematic and more telling is the utter, here we go, perhaps even more problematic and more telling is the utter failure of defense counsel now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete and the defendant ready for trial. Instead, the defendant seeks an unbounded continuance with no apparent plan to complete the review of unspecified evidence that counsel claims it has yet to review. This is not sufficient to warrant a continuance. Like, he is sticking it to her. Like, he is saying your batting of your eyelashes and your tons of information in disclosures really is holding, it's like a bucket with holes in it. You don't specify what information you expect to find, what that information entails, how it would affect maybe the case, or show that there could be an alternative perp, etc. He goes into more detail in the next order, but it's crazy how he is calling her out. It's like, it's almost like I expect more from a death penalty qualified lawyer than what I'm getting from you, is basically what he is saying to her. Okay? Okay. Defendant has not established a continuance as necessary to conduct a more thorough, here we go, he's going to stick it to her again here, life history investigation and identify necessary experts. The defendant argues next that he needs additional time to investigate and prepare mitigation evidence, which he contends is necessary to uphold his constitutional rights, particularly those under the 8th and 6th Amendments. Specifically, the defense team claims that to be effective, counsel must conduct an exhaustive and comprehensive dive into the defendant's life history. For additional mitigation evidence, analyze the information to a cohesive narrative for the jury and identify any additional behavioral, cultural, scientific, and or mental health experts that may be necessary to develop the mitigation presentation. He's already seen 3 of these doctors that dove deep into his health and family health and his upbringing and all these different things, right? Despite having hired a mitigation team 2 years ago, and they've been going over his life history and medical and everything for 2 years, defense counsel contends that recently discovered, and they blacked it out, has raised red flags. Well, red flags isn't evidence, right? That the defendant may have, they're going to say that the defendant may have something else now. According to a defendant's primary mitigation investigator, attorney so-and-so, and blah, 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 her team of 4 have been, so this attorney and 4 other team members have been diligent in their investigation into the defendant's life history. But there have been blah, blah, blah. She believes that with time, she will be able to uncover some of these barriers by whatever this is. And this was an ex parte hearing. Obviously, the judge denied it. It's like, okay, well, let's let him sit in jail a little bit longer. Let's see if he can go really stir crazy. And then we can say that he has something else now too, right? The defendant has not demonstrated a continuance to accommodate further investigation is constitutionally required. The 8th Amendment requires that a capital defendant be allowed to present all relevant evidence in mitigation. Oh, there is, Jean, huge difference between Judge Hippler and Judge John Judge. The 8th Amendment requires that capital defendant be allowed to present all relevant evidence in mitigation, and they cite a case. In addition, a capital defendant has a 6th Amendment right to a fair trial and effective assistance to counsel in both the guilt and penalty phases of a capital case. They cite another case. As defendant points out, defense counsel is constitutionally required to conduct a thorough, okay, under what she is claiming the ABA, okay, and under that, what it states there that defense counsel is constitutionally required to conduct a thorough investigation in preparation for the penalty phase of a capital case. A thorough investigation, okay? Presentation of some mitigating evidence, even if strong, is insufficient if other mitigating evidence is available upon reasonable investigation. The assertion that counsel needs a continuance to conduct an exhaustive and comprehensive dive into the defendant's life history for additional mitigation evidence overstates the extent of counsel's constitutional obligations. Counsel's investigation into mitigation evidence must be reasonable. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required, okay? This is both the Supreme Court and the United States Supreme Court, hold that the defense counsel is not required to investigate a defendant's entire life in order to present constitutionally sufficient mitigation evidence. Okay? They are only required. Where did it go? Anyway. I just read it. A thorough investigation. That's what they're supposed to do. Anyway. So, counsel's investigation into mitigation evidence must be reasonable. Okay. We emphasize that Strickland does not require counsel to investigate every conceivable line of mitigating evidence, no matter how unlikely the effort would be to assist the defendant at sentencing. While the defendant notes that the ABA guidelines for mitigation function of defense teams in death penalty cases urges counsel in death penalty cases to conduct an ongoing and exhaustive and independent investigation of every aspect of the client's character, history, records, and any circumstances of the offense to meet their constitutional obligations. Courts look not to what is prudent or appropriate, but only to what is constitutionally compelled. He is going to call her out on this because she cites that this is what they're supposed to do, and the judge says otherwise. In a capital case is instructive here. On post-conviction, Rowe argued her counsel was deficient, so they're going through this other case that Ann Taylor cited, and he's saying it's not the same case or instructions or mitigating evidence or background stuff. This is nowhere near the same as Bryan Kohberger, okay? The court rejected this claim, holding that counsel was not required to investigate Rowe's entire life in order to objectively and reasonably present Rowe's mitigation evidence. The court further noted great lengths counsel underwent to investigate and present mitigating evidence from several of Rowe's friends, health and welfare records, letters from friends and family, and veterans administrative records concerning Rowe's husband, previous injuries, and the couple's relationship. The investigation the defendant's experts have undertaken over the past 2+ years far exceeds that in Rowe, and in fact, readily appears to satisfy the relevant ABA guidelines cited by the defendant. It includes, but is not limited. So this isn't even the list of everything that they have done in Bryan Kohberger's case, looking into his whole life. Hello, Nikki. Okay, so they have done, this is what the defense has done in Bryan Kohberger's. Defendant K, PhD education records, including coursework, interviews, and correspondence. The defendant's mental health and medical records, including, I don't know what this is, they blocked it out. Records related to childhood car accident, defendant's employment records, mental health, education, and employment records of the defendant's sisters, mental health records of the defendant's parents, father's military records and social security records, court records from multiple generations of Kohberger family on the paternal side. Multiple generations they've gone back, you guys, trying to find something that they could say, you know what, Bryan Kohberger has this or may have it. We got to look into that. Sorry, you guys, I had to take a sip of my coffee there. VA records and death certificates from maternal and paternal uncles, multiple interviews with the defendant and each immediate family member, interviews of 2 of the defendant's 4th grade teachers, former boxing coach, and psychologists who evaluated the defendant in 2005, interviews with multiple members of the defendant's extended family on the maternal and paternal side, interviews with the defendant's professor and advisor of DeSales University, interviews of the defendant's former co-worker, interviews of at least one family friend, and letters and jail calls between the defendant and his family. Like, they've gone over right back until he was a kid. They went into generations of court records and medical records and everything of his family. That is above and beyond what needs to be done to just to cover the ABA guidelines. Okay. And they've gone above and beyond those guidelines. It is evident from the reports of the defendant's mitigation experts, Dr. Orr, Dr. Ryan, and Dr. Brams, 3 doctors, that they have developed an expansive understanding of the defendant's family. Okay. Environmental and social okay, so let's get back up in here. Brams, that they have developed an expansive understanding of the defendant's family environment, social development history, family history, both nuclear and extended over multiple generations, educational history, and mental health and medical history. From this evidence, these experts have rendered several current diagnoses and identified other diagnoses for which the defendant met criteria at some point in his life. Doesn't mean he is, he has that now, right? So Jean says, Rose, seems like Ann Taylor is working on death penalty mitigation more than the actual defense. Yeah. Well, this is what she's fighting right now, why she needs the continuance. Despite an extensive investigation, defendant claims additional investigation is warranted to identify probably something that they found in this nuclear or extended over multiple generations, something that somebody in multiple generations ago might have had. However, the defendant has not established that such investigation is constitutionally compelled, particularly given the extensive work already completed. Rather, the claimed need is based on unqualified speculation by, and they block out the person or persons, right? So did they come across something generations ago that maybe his great 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 grandmother, grandfather, great 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 cousins had some kind of psychotic health issue that they want to now test Bryan Kohberger to see if maybe from 6 generations ago, maybe it's come through onto him. You know what I mean? Because somebody brought this up and they are saying it's based on unqualified speculation by somebody. Defendant has not offered any declaration by any of his disclosed mitigation experts opining the same. So none of these experts that they had, these doctors from up here, Dr. Orr, Dr. Ryan, Dr. Brams, none of them opined this same unqualified speculation that this person did. Nor has he pointed to anything in their expert reports that would support this person's speculation. As noted, a continuance of trial is not warranted to chase down mere speculation that potential evidence exists. Further, the defendant has not set forth a plan for a continued investigation, how much time it'll take, what this team expects the investigation will reveal, why it's necessary to uphold his constitutional rights, and why these matters are only now being raised with the court. So it's like, you can't just throw something like, okay, 3 generations or 4 generations ago, this could have happened, this could be generational, and we need to. They've given no timeline, no time frame, no data, no, these doctors don't even opine the same thing. These experts, they never said nothing about this stuff maybe affecting him now. It's just this unqualified person speculating that, oh, maybe he could. Let's use that. You know what I mean? Okay, additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. Thus, there remains significant time for so-and-so, who is not an expert, he's unqualified speculation, and her team to continue their investigation and supplement expert disclosures if warranted. Now, a lot of this is blacked out. One, speculation that the defendant, blah, 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 is simply that speculation built on circumstantial evidence, blah, 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 blah. They blocked this all out. I don't know what was said before here. Conditions. So they're trying to see or say that, 4, 5, 6 generations ago, there's conditions that, these people may have had that Bryan Kohberger may have because they have conditions here, which are currently attributed by his own mitigation experts to his ASD, OCD, and or ADHD, are consistent with childhood trauma. There is evidence of poverty, both generational and familial. This is all blacked out. Notably missing from so-and-so's declaration is any indication as to how she intends to confirm her suspicions or how long she expects it to take, be that months, years, or even decades. Defendant has been subject to multiple lengthy interviews by several different experts over the past 2 years. Based on the expert reports reviewed by this court, blah, 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 blah. Defendant's family has likewise been extensively interviewed, and there has, and they blocked this all out, been no report that blah, 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 blah. None of the defendants, blah, 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 have raised the alarm that blah, 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 despite having the same information, blah, 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 relies upon. So, I don't know what this could be, but I think the family is saying, no, there's nothing like that in our family. We don't know about that. We know maybe 10 years, 10 generations ago, maybe. Anyway, it's all been blacked out, so we can't see it. Instead, it is an invitation for a perpetual continuance. More importantly, aside from the blah, 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 all of this information has been available and documented in the record for months. Yet again, the defendant is only now moving for a continuance for further investigation into this person's unsupported, suspicious smacks of tactical gamemanship and delay. Like, here's another dig, right? Unsupported suspicions, smacks of tactical gamemanship and delay. Absent more compelling evidence that blah, 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 a plan for, this is crazy, uncovering it, and a reasonable timeline to do so. There's no constitutional basis for further investigation, particularly on an open-ended basis with no plan to bring the matter home. Like, it is crazy, you guys. Right? Well, look at some of the other stuff that she filed from the 1800 law that should still be law today, even though new precedences and everything have been set. Crazy. I mean, you got to give her an A+ for trying everything under her power to get this death penalty off the table. Like, right now, she's not fighting for a not guilty verdict. She's fighting for his life, to spare his life. That's what she's fighting for. She knows that at this point, he's cooked. Right now, she's not fighting for a not guilty verdict. She is fighting to save his life, to have this death penalty removed. It's very evident in all of these filings for those who, have worked in the legal field or do work in the legal field or, have gone through legal cases, maybe similar. Well, I hope not, but right? I agree, Carol. Just because it's in your family history from generations ago doesn't mean that it's going to affect you. But this is what they seem to be wanting to do. Nevertheless, this person who, again, is not even marginally qualified to opine, believes that there is evidence that this and seeks additional time to unearth it. Well, it could be there, but I haven't found it. Like, come on. Her support, which she has not provided to the court. Again, not one of the defendants, blah, 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 experts who have had the same information This person has submitted a declaration stating that they may change their diagnosis based on further investigation of this person. Rather, it is based on so-and-so's speculation that further investigation might change these doctors' minds. Such speculation is not grounds for a continuance. I wish we could see through this. Because look at, you guys, there's a lot that's redacted. Not only is there a lack of support in the record for this, whatever this is, anticipation that more investigation into blah, blah, blah to change their minds, Blah and her team and defense counsel have known since November of 2024 that so-and-so was going to try and do this. Neither the defense team nor so-and-so have articulated what efforts they have made, if any, since that time to understand the basis of blah, 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 blah. Further, they have not indicated what plan they have to obtain this information if a continuance is granted or how long it will take. In sum, the defendant has not demonstrated that a continuance for further investigation into potential mitigation evidence is necessary to uphold his constitutional rights. The right to present mitigation evidence and the right to effective assistance of counsel does not necessitate an investigation of his entire history. They simply require that the investigation be reasonable. While easily available mitigation evidence cannot be ignored, defendant's briefing demonstrates that the evidence they are attempting to obtain is far from easily available and in fact may not even exist. Further, the evidence prompting the need for further investigation has blah, 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 been available for months, yet it is only now that the defendant seeks a continuance. This tactic seems geared towards achieving a delay rather than a good faith effort to obtain meaningful mitigation evidence. He's calling her out. He's calling her out for her BS in just delay. Moreover, the defendant provides absolutely no plan for how further investigation will proceed, who will be interviewed, or how long it will take. The Constitution does not demand, and this court is not willing to continue the trial indefinitely to allow the defense team to embark on a fishing expedition, pulling at every conceivable thread in the defendant's familial tapestry. Right? Like she wants to go back until what, the 1600s? I don't know. We know she's already gone back to the 1800s. So, like, this is crazy. Counsel's assertion that they will be better prepared with more time and more evidence is an assertion shared by every lawyer involved in a trial. At some point, and particularly after 2.5 years of investigation, the defense team must be satisfied with what they have, which in this case is extensive. In addition, while the crime victims have rights to a timely disposition under Article 122 of the Idaho Constitution, IC 195306, do not trump the defendant's federal constitutional rights. They provide an additional justification for proceeding with trial as scheduled. For these reasons, a continuance is not warranted. Yeah, he is like, woohoo, screw you. Like, you're not going to play them games in my courtroom. A continuance is not warranted due to pretrial publicity. Now, we'll read a bit of this, but he already basically went over this in the last motions hearing. And in this here, he's just saying that, okay, the defendant's next seeks a continuance due to recent inflammatory pretrial publicity. On May 9, 2025, approximately 3 months before trial is set to begin, Dateline NBC aired a 2-hour episode about the case. This episode included details and materials about the case, which, if true, are not publicly available and which promote a narrative of guilt. The defendant also advises that on July 9, 2025, Amazon Prime Video is planning to release a 4-part docuseries about the homicides, and on July 14th, crime author James Patterson is set to release the book. I got that book on pre-order, and one of you guys are going to win that book. I'm going to go through it. I'm going to comment on it, and then one of you will be winning that book, and I will send it out to you, just like I did the last book. It is set to release a book he wrote about the same. Yeah, and it was like $48 or something, this book plus tax for me in Canada. It's crazy. But one of you guys may want the book. Okay, defendant contends that this media coverage so close to trial threatens his right to a fair trial by an impartial jury, which can only be ameliorated by a continuance. In addition, defendant argues that a continuance is necessary to investigate the source of the leaks to the media and pose accountability. That has nothing to do with the trial. Nothing. Investigating and seeking out who leaked the information has nothing to do with the trial. Nothing. The court does not agree that either argument compels a continuance. So this just goes through where he says that they're taking extra precautions, and I do think that the jury may be sequestered, you guys. Because the judge is going to take extra precautions. I am going to scroll through this slowly, so if you guys do want to go back and read it all later, this is all stuff he's already said in court, except for the order that it's been denied on this reason too. And he says, like, this information is going to come out in trial if it is in fact evidence. Okay, just because it's said in a documentary doesn't mean that it's true. Do we think so? Yes, but the evidence is going to be coming out in trial. So he also, states in this too that there is, people out there that don't follow true crime. They got a jury seated for Chad Daybell in a death penalty case. It was very well publicized, just as this one was. And they got a fair and impartial jury on that case too. So, and there was, he faced 3, the 2 kids and his wife. So similar, and they got a fair jury. So the judge is basically saying, we are going to even take extra precautions in this voir dire. It's going to be an extensive voir dire, and I am almost thinking, you guys, that the jury is going to be sequestered. Shepard was not granted a change of venue to a locale far away from where the publicity originated, nor was his jury sequestered. And this, in him putting this in here, kind of has me thinking that because he's talking about this other case that was, extensively covered, just like this case is. And he's saying that he didn't get a change of venue and his jury wasn't sequestered and they got a fair jury. But to me, they've got a change of venue. And with him mentioning this jury sequestration, I do believe that he is going to sequester the juries. The court found there was no doubt that this deluge of public reached at least some of the jury, given that when the jury was questioned for the only time, the 2 jurors admitted in open court to hearing the highly inflammatory charge. So this is in that other case. They're talking about Shepard's case. See, ultimately, whether defendant can receive a fair trial depends on whether a fair and impartial jury can be seated. He goes through more. He's citing different things here. Okay, so they're just talking about the previous case here. So then he goes on to say, with the measures the court has already put in place to protect the defendant against pretrial media coverage and the court's carefully crafted jury selection process, there is no reason to think that an impartial jury cannot be seated through a searching and robust voir dire. In addition, while continuances may be appropriate if pretrial scrutiny is reasonably expected to fade with time, it is an ineffective tool where publicity is such that there is no reason to anticipate that it would subside by any delay, which would not put off the trial indefinitely. So he's saying it doesn't matter if we put off. Actually, if he was to delay this trial till next year, there would be even more publicity, right? Because everybody's going to be pissed that it was put off again, because they're on the third trial date now. This is the third trial date because this is not starting August 11th. It was supposed to start August 11th. He has put it off. Not a lot, thank the good Lord. Oh, thank you, Lord. But this is the third time the trial date has been changed. Okay, the court observed that the Sixth Amendment's guarantee of a speedy trial is one to which the government and society, as well as the accused, has a claim, and stated that society cannot be utterly deprived of the right to prosecute and try someone for a crime within a reasonable time merely because of widespread community knowledge. So he goes on and on. Here, there is no assurance that the pretrial publicity will fade with time. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative. 4 college students in a small Idaho college town were brutally stabbed to death by an unknown perpetrator. It was an immediate media sensation and garnered widespread attention that not only continues to persist, but continues to grow. Your screen went out? You might have to go out and come back in, Rose. Everybody else's is okay, so go out, Rose, and come back in. "18 months ago, a defendant moved for a change of venue from Latah County due in part to the extensive inflammatory pretrial publicity and allegations made about Mr. Kohberger to the public by media that will be inadmissible at trial. The motion for change of venue in January 30th, 2024, he argued that Latah County was not large enough to avoid the bias caused by the persuasive prejudicial publicity." Whew, there's a tongue twister. Defendant's motion was granted, and as a result, the trial date was continued by approximately 10 weeks. It was supposed to go ahead in June. It was moved to August 11th, and now it's been moved again to August 18th. So this is the third time. Those additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience, which is clamoring for answers. The longer the public is made to sit and wait for the facts to come out at a trial, the more time there is for inflammatory speculative stories, movies, and books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with trial as scheduled will likely avoid negative consequences from future publicity. Thus, the court finds the continuance is not warranted based on the medial coverage. Rather, careful and patient voir dire is prescribed. And here they go on. The continuance is not warranted to investigate the leak of the information. Defendant also inserts that a continuance is necessary to accommodate the special prosecutor's investigation into the source of the leaks to the media and to impose accountability. Now, this investigation can go on. We've seen this in the Karen Reed trial. It's going on still behind the scenes. It is no reason to continue the trial. But she says that he argues that if any of the leaks came from witnesses the state intends to call or from others involved in the investigation, the information is Brady material because it would serve to impeach the leaker's credibility and may be exculpatory in nature. He adds that if the investigation reveals that other state agents had information about the leaks but failed to disclose it, this omission would constitute a Brady violation. As noted, a constitution is not warranted where the information sought thereby is mere speculation. Defendant's Brady argument is built on a house of speculative assumptions, an assumption that there was a leak by persons bound by the non-dissemination order. They don't know who gave out this information. An assumption the leaker will be found, an assumption that the leakers were law enforcement, an assumption that the leaker or others who may B were complicit will be testifying as government witnesses, and an assumption that these witnesses will likely be material. Such assumptions are not grounds for a continuance, particularly given that there is no guarantee if and when they will be confirmed or debunked. This trial cannot be held hostage indefinitely to the outcome of an investigation, particularly given the significant chance the leaker may never be discovered. Because NBC is saying, nope, privileged. Nope, it's privileged. We're not giving up our informants. So he says, based on the foregoing, the defense motion to continue is denied. Okay? But this is what peeves me off. Let's stop. I don't know if I can just change to this. No. Okay, so let's go to the case summary. Let me blow this up. And let's go here. Let me share this with you. This is what pissed me off. Okay, so okay, so this is what we just went through. We just went through this. There's a new scheduling order. It's not up on the site yet. Well, I think it is. It is. We will go over it. So the next hearing is scheduled. Look at this. Sealed proceedings. These are more motions and everything else that's going to be going on prior to anything else starting. Jury selection is going to start August 4th. It was supposed to start the end of July. But now from July 28th to August 1st, there's sealed proceedings that are going to be happening. This hearing is now canceled. Hearing scheduled. This is the voir dire, which is going to start on August 4th. The jury trial is now not starting until August 18th, where before it was August 11th. So the date has been changed. Let me see if I can... hang on a sec. Okay, let me share this. Let me make it bigger for you guys. Okay, so here's the amended scheduling order. This is for people on cell phones that watch this on cell phones. I'm trying to make it as big as I can for you. The court's prior scheduling order is amended as follows. Sealed proceedings with court and counsel will take place July 28th through August 1st. Jury voir dire will commence on August 4th rather than July 30th, 2025, and continue until a jury is seated. It is estimated that the trial itself, beginning with opening statements, will commence on August 18th and continue until completed. So I think that this is really messed now with the time schedule that they had set aside for the court. So I won't be surprised if there's some weeks that there's only going to be 2 or 3 days of the trial because the court already was booked for something else. Right? So I feel like there's going to be delays in certain parts of this trial because now the time lot that they had booked for the courtroom for this to start, I know it's only 7 days, but that's huge when it comes to setting time aside for courtrooms, right? That's why they always ask, okay, you want a hearing? How long is it going to take? An hour? Okay, we'll set an hour and a half aside just in case it goes over a bit and it gives them time to get all their shit out of the courtroom for the next people to come in to use that courtroom. That has all been thrown up in the air now. They're going to have a whole week at some part of this trial that they've got to make up to keep it from going over the time that they had set aside for this trial. Oh, it's crazy. It's crazy, you guys. Okay, my throat is killing. Okay, so let's get rid of that. I don't know if I'm going to read through all of this, you guys. It's 7 pages. My throat is so sore right now. I just read through 20 pages nonstop. Okay, so this is the redacted order on the defendant's order of proof, alternate perpetrators. A lot of this, maybe we'll get through it. We'll see what my voice. I am going to scroll through it though, so if I do happen to skip parts, you guys will be able to watch the replay and you will be able to read through it yourself. Give me 2 seconds here. All right. Introduction. The state previously moved in limine, seeking to preclude the defendant from offering or arguing alternate perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order on the motion, defendant filed his offers of proof and evidence in support, identifying 4 individuals as potential alternate perpetrators. I wonder who they were. I bet you Kaylee's boyfriend was in there. I bet you the guy from that Ethan had words with that night at the party. I don't know. I don't know who else, but I bet you those 2 they were trying to claim. Maya Millette, yes. Okay, but they're going to give us some indication, you guys. So pay attention to this because I'm going to be asking you guys who you think these people are. Because there are parts of this where they mention, without mentioning their name, who they had connections to. Okay? The state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard of State versus Meister. Defendant conceded at oral argument. So the defendant conceded at oral argument that at this point, his proffer did not sufficiently pursue an alternate perpetrator theory at the outset of the trial, but requests latitude in cross-examination of the state's witnesses to try and establish additional evidence to satisfy the Meiser standard. The court concludes that at this time, the defendant's alternate perpetrator proffer is inadmissible under Meiser, as it is irrelevant and or excluded by IRE 403. However, this does not foreclose defendant from cross-examining law enforcement regarding reasonableness of its investigation and its follow-up on plausible leads. Okay, so they're going to go over the standard. We're not reading all through this, but here it is. If you guys want to go through it, you can go back and look at it later and pause it. I will stop at the parts where they're giving some indication as who it could be. Okay, here the evidence defendant has offered perpetrating to establish the 4 individuals as alternate perpetrators abjectly fails to meet the Meiser standard. Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. Here we go. 3 of the individuals were each socially connected to one or more of the victims. So this is interesting. Okay. So 3 of the individuals they tried to say were alternate perpetrators were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide. Okay. So hoodie guy, Kaylee Goncalves' boyfriend, and the guy at the party that Xana and Ethan were at. That's the 3 that I think they're trying to say were alternate perpetrators. For this, there's still one more. They blocked out all this, so they gave the names and everything of the people, the party, and they probably brought all that up. They brought up the hoodie guy. They probably brought up Kaylee's ex-boyfriend. Okay, and somebody here, okay, with one or more of the victims at social events in the hours prior to the homicide, lived with it, and they say all these people here, or one, or all of them, or 2 of them, or maybe none, I don't know, lived within walking distance of the crime scene and were familiar with the layout of the victim's home from prior social events. So these 3 were previously at their place. So one of them is definitely going to be Kaylee's ex-boyfriend, because he had been at that house before, right? Was Hoodie Guy ever at their house before? And was the guy that Ethan got into an argument with over at the party that he and Xana were at, was he ever at one of the parties there? We don't know, right? But they're saying that they were within, 3 of them were within walking distance of the crime scene. Well, perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles. There is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them or a means to do so. Further, I want to hide this for a minute. There's a Freudian slip here. I think this should have been blocked out, but it wasn't. Okay? While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there is no compelling evidence that any of them had a motive to kill them, much less physically harm them, or means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and the victims. So there was DNA on the victims of other people. Now, we know that there was Kaylee, I think, DNA under Madison's fingernails. That could have been from them grabbing each other during this fight that happened in that room with the perpetrator. But if they knew that this DNA was Maddie's under Kaylee's nails, and this under Maddie's nails was Kaylee's and somebody else's, they have other DNA. Now, is that the only DNA, or is there more? We don't know. We'll find out at trial, though. The 4th individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. This is the one that Kaylee thought was stalking her. He followed her briefly out the exit of the store while considering approaching her to talk. He turned away before ever speaking to her. The event was captured on surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternate perpetrators. Okay, so that was the 4th guy. So this 4th individual was that one that they thought was stalking her, or she thought was stalking her. Lab reports excluded his DNA from the samples taken from the crime scene and victims. There is no evidence connecting him to the crime scene. So there you go with everything that they are claiming here. Collectively, the defendant's proffer with regard to these four individuals fails to give rise to even an inference that they committed the crimes or otherwise make it more or less likely that the defendant was the perpetrator. Therefore, it is irrelevant under IRE 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. At best, the defendant's offer of proof can give rise to only wild speculation that it is possible any one of these four individuals could have committed the crimes, which is inadequate under Meister. Again, mere inferences that another person could have committed the crime will most likely not be relevant. In other words, it is not sufficient for a defendant to merely offer up supported speculation that another person may have committed the crime, which is all defendant has done here. Yeah, there was an argument or something that Ethan had with someone at that party. But none of them were shown on camera ever going there and stuff. They would have had evidence of that. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded by IRE 403, as the 10th Circuit noted regarding alternate perpetrator evidence. It is not sufficient for a defendant merely to offer up unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. So again, he's just going over that again. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Nonetheless, the court's ruling does not preclude the defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in following up on and ruling out leads. Indeed, the Idaho Courts of Appeals recently found an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to an alternate perpetrator analysis. Right. Like I said, there's so much other evidence that now that we've seen the car on video and everything, and yeah. Okay. So the order, based on the foregoing defendant's offer of proof for alternate perpetrator, it is denied. So it has been denied, which is good, you guys, because that's just wild. Let me see if anything else is here. And while the judge already condemned her for no basis for this, how can I say it? Her accusing the prosecution of not handing over discovery. What does she do yesterday? She submits another request for discovery, supplemental, which just basically says, if you have anything else, you better turn it over, for the 24th time, after the judge already condemned her for accusing them of not turning over the discovery, because the court has found no such thing, that the prosecution has not turned over evidence. Okay, let me just check here. Nothing new in the Barrymore few case. I wanted to check that. So what did you guys think? I'm surprised the defense isn't saying DM and BF are alternate, right? I'm thinking, because they said they all lived within walking distance of the house, I don't know where the hoodie guy lived. If anybody knows what, but I'm thinking the hoodie guy, Kaylee's boyfriend. Now, see, I forgot who I said the other one was. Oh, the guy at the party that Ethan and Xana were at, Xana. And now we know that the other one that they were trying to name was the guy who kind of followed Kaylee around the store and tried to maybe interact with her, but lost his nerve. Yeah. Okay, Rose, thank you again for your gracious and donation. I appreciate you so, so much. It's a lot of time it takes for me to grab this stuff and get it together. And I've gotten a lot more stuff to go over with the Barry Morphew case, too. I'm still trying to get verified information on some stuff that I've come across. So I appreciate each and every one of you who do donate to the channel. I appreciate it so much. So I will see you hopefully again soon. Sunday, we're going to have mini reads. We are going to have the mini reads on Sunday at 1 p.m. Eastern. So if you want a mini read for yourself, come and see us 1 p.m. Eastern on Sunday. Yeah, I don't think so either, Carol. Like I said, they all gave DNA samples and they were ruled out. Yeah, I want to go back through all my documents too. Aw, thank you, Rose. I love you. Um, let me just see. Jean says, thank you for magnifying the documents. I try to blow them up as much as I can, you guys, because I know that a lot of people do watch on their phone. So I do try and blow it up as much as I can. So I'm glad you appreciate that. Carol says, you're the best friend of what? Oh, us. Aw. I love you guys. So that is what we've got. It has been continued. And I think that was more or less the judge taking that extra time for the voir dire. And he feels it's going to run into the 11th. So he may have implicated a little bit more with the voir dire just to cover the media presence and everything that's coming out. It's only 7 days, kind of screws with my schedule because I rescheduled a lot of things to cover this trial, including going back to my hometown. So it kind of peeves me off a bit that I'm losing a week there. Yes, I bring out verified information. If I don't know for a fact, I will say, look at guys, I've heard this. I have not been able to verify it. So I don't know if it's true or not. This is what's being said. I'm going to look into it. So thank you. Thank you for that. I appreciate you. Right? They've ruled him out too. That's been rolled out in the Suzanne Morphew case. Thank you, Nana. I appreciate all my mods too. Like, you guys are the best. You guys rock. Carol says, it's on my calendar. Yeah, so I'm going to have to finagle some stuff now to cover this. I don't know to what extent right now is what's happening with the Barry Morphew case. That probably is not going to go to trial for another year anyway. So, but so far right now, we are not allowed to live stream the Barry Morphew case. So that kind of peeves me off. I think it should be open. and I think we should be able to see it all. Now, from what I understand, we are allowed to see certain parts, like the arraignment and stuff like that. Are we allowed to live stream it? I don't know. It's so confusing, the orders that were set down by the judge in that case. So we'll have to wait and see as that grows closer. I don't think his case is going to go through unless he demands a speedy trial. But I can guarantee you guys that they've got every dot crossed. They had every piece of disclosure, everything ready to hand to him once he was arrested. I can almost guarantee you that because of what happened in the last trial. I guarantee you they had every single piece of paper that they needed to disclose, every little bit of evidence, everything that they need to disclose. They probably had it already together and ready and waiting for him to be arrested, and they hand it all to them. There you go. I have not heard that, Jean, so I cannot verify that. The grub truck driver had nothing to do with this. Nothing. The only reason the grub truck was even brought into this is because Kaylee and Madison had stopped at the grub truck to grab food on their way home after the bar. And then there was, I don't know if you're confusing the two, but there was also a driver that they had that drove Uber. And they wanted to know if he was still out working because they were going to go back to the grub truck to grab more food and then change their minds. But he was not a driver for the grub truck, if that's what you're referring to. My brain yeah, I've got tons of stuff I've got to go through on my other computer and get that information transferred to this one so I have it available in case we have to go back to it. But I've got some time to get that done, so it's a big uh it's a big feat, you guys. I think I'll just put it all onto an external drive. Thank you so much, Regina Carter, for your $5 super chat. She says, thank you, Willow, for all the work you do. Thank you, you guys, for putting up with me and listening to this voice for an hour and a half. I think I did pretty good. But the new driver, I'm not sure what you mean by that, Carol. I haven't heard of another driver come out. I heard about the girls when Maddie and Kaylee had gotten home. They had all decided that they may want to go back out and grab some more food at the grub truck. But when they called the driver, their Uber guy or whatever, he wasn't available. So they didn't go. That's the only new thing that I heard about a driver. But I don't think he was a delivery driver for the grub truck. It's not something I can verify, so all I know is what I read in the affidavits that she was arrested and said she has to testify. That's the delivery driver for Xana's food. For the Jack in the Box. Thank you again, Regina, for that. I appreciate you so, so, so much. Okay, now I know what you're talking about. She was pulled over, and she said that she was in the car and had seen Bryan Kohberger's car. She was next to the car. She was arrested and said she had to test. Yeah. I got it. She said, park next to him. Yes. Now, did she actually see him? We don't know, right? We only seen parts of her statement. We don't know her full statement. Did she actually see his face? We don't know, right? Yeah, she was the DoorDash driver. She was not a driver for the grub truck. Xana had ordered from Jack in the Box. Aw, you're so sweet. Thank you, Regina. Beautiful picture, too, by the way. I love your picture. Yeah, that driver wasn't for the grub truck. That driver was for that delivered Xana's Jack in the Box. And then I do know that the girls had all at one time called their friend that was an Uber driver. Hey, are you still out driving around? Because they thought about grabbing some more food, but then changed their minds. So I thought that's what the one. Oh, you're so welcome. You are so welcome. So that's what we got for now. Oh, there's Jean too. Oh, thank you, Jean. Jean P, thank you so much for your $2 super chat. I appreciate it so, so, so much. And she says, I appreciate you and all the hard work, Willow. Thank you. It's nice when I see that people appreciate the hours and hours that I put into this. The night that I found out that Barry Morphew had been arrested again, it's like, okay, I'll look at it all tomorrow. Nope. I was up 1, 2 o'clock in the morning and I had to go over the documents and look at things and start investigating because I couldn't sleep because it was on my mind. It's like, Suzanne, you're finally going to get justice, my love. You're finally going to get justice. This beautiful woman deserves justice. And I couldn't sleep. So I got up and worked almost through the night. Went back to bed around 4:30 in the morning and got up at 6. So, yeah, for the delivery. That was Xana's delivery for the Jack in the Box. That's who that female delivery driver was. And that's the one that was there at 4 a.m. delivering Xana's food. I'm sure she said that she's on the witness list, so I'm sure we're going to hear more. But probably not until trial. That's for sure. I don't think there's going to be any more leaks. Let me just write this down before I forget. You guys know me and my memory. Oh my gosh. I gotta write this down. I'm gonna forget. I swear. I am so bad. Okay. Carol says, I appreciate you, but I'm broke. Hey, being here, subscribing, hitting that like button, I appreciate that so much also. So don't feel like if you cannot afford to donate, I don't want you to donate. But if you can afford it without messing with your finances, I appreciate it. But hitting that subscribe, hitting the like, sharing this out, I appreciate just as much. Regina says, it is the Morphew case and all the work you did that got me hooked on you, Willow. Oh, thank you. Yes. Me and my brother, right from the beginning, we did have others on our team at the beginning with the Barry Morphew case, which we got rid of for good reason. And then Martin joined, and then Jules joined. Jules is not, there's 2 Jules out there. I'm talking about Another Day in the Car, Jules. So if you want to subscribe to her, look her up. She is called Another Day in the Car. I think she might have Jules in front of it. Jules, Another Day in the Car. But that is her YouTube channel. You can go and check her out too. She lives in Colorado. And she worked very closely with us also. So yeah, we did a lot of work. My brother and Martin dove deep. I don't think you've heard the end of them. So just give it some time, you guys, and let them collect their bearings. And I hope to see them here again soon. Maybe I will even have them here. You never know. But you will know if you're subscribed and you have your notifications set to all, you will know if I get them up on the channel, right? And get their perspective of what they're thinking now. But I think some time has to pass. They both took it really hard when this was dismissed without prejudice. Thank God it was without prejudice. But yeah, their heart and souls were into this case. So with that being said, I'm not going to take up more of your time that doesn't need to be taken up with just filling in with words. This is what we have so far. Yes, Jean says yes. Yeah. Like I said, me and my brother, AK, were here since the beginning. We started a team, lost some along the way, picked up Martin and then picked up Jules. And I'm telling you, to me, it's the dream team. So we've got a good team. Let's see what happens. I'm not going to push things, but we'll see if I can't get Martin and my brother back up on channel, maybe even Jules too, if she will come up. I don't see why she wouldn't, but I don't want to push Martin and I don't want to push Kurt. But Jules' channel name is Another Day in True Crime. Okay, so she's changed her channel name because it used to be Another Day in the Car. So thank you for that, Nana. You rock. Nana rocks. I remember when I said, Nana, I'm going to make you a mod. She says, oh my God, my dear, I don't know anything what to do. I don't know how to do things. I says, don't you worry. You are going to be my mod. And she has come so far. Don't mess with Nana because she will block you. You come on here causing trouble or anything, Nana is quick to block you. So you better be careful with Nana on board now with us too, as well as all my other great mods. K-Mitch, Summer Dawn, Cat H, Des, Rose. Like, I've got about 8 mods, you guys, and some work. We've got Juror 11, but most of my mods are generally here. And Nana, for sure, is always here. And I just love you to death for that, Nana. And she's on it. Look at that. Look at how far she's come. So thank you for correcting me, Nana. Jules, Another Day in True Crime. That's her new channel name. So without a further ado, you guys, I'm going to say, like I always do, please take care of yourselves. Please stay safe. You trained me well. Oh, Nana, you picked up so quick. You picked up so quick. Okay, so with that being said, you guys, I'm going to wrap this up. I'm going to wrap it up like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings and watch who you trust. I love you guys to the moon and back. Hopefully, I will see you guys all Sunday, 1 p.m. for the mini reads. If you would like your very own mini read, come and see us Sunday, 1 p.m. Eastern. Get your own mini read.